Screen is visible to you?
Yes, sir. It is visible.
Okay. Okay, good. So we will be doing administrative law, right?
Right,
So
sir.
administrative law, public interest litigation, these two are rather important concept-based subjects where there is no specific Bail Act for these two subjects. Okay. So administrative law, basically, what is the purpose of administrative law? That is important. Okay. So what is the purpose? So administrative law, because now governments, earlier it was very small. Government functions were limited. That was only to provide security to the country. And for that, they used to raise some taxes. So there was very limited administration on the part of government. That is to maintain revenue records and to have provide security. So there were very limited functions. So everything was taken care by single administration only. There was no specific administrative law. So administrative law was part of constitutional law. But over the period, because the role of governments are increasing, they thought that they should have a separate law for administration also. So for that, they started evolving administrative law. It was very old also, but it started in the late 19th and early 20th century. This separate concept of administrative law started evolving. Okay. We'll discuss when it started, that one, who started, basically how it developed, growth. We'll discuss in the coming slides. So what exactly is the sources of administrative law? See, administrative law, basically, as I told, it is part of constitutional law earlier. So constitutional law automatically, it is from constitutional law only, because all government related activities like judiciary, executive, legislature, everything is part of constitution. So it is extension of the constitution. So that is the reason, even in the questions or the subject what we discuss, we say that this administrative law and public interest litigation, and to certain extent environmental law is also, even though there is separate legislation for these things, they are linked to the constitutional law only. Okay. Then precedents are judicial precedents, what we call. So any previous precedents like judicial orders, all those things are also sources. Then statutes and delegated legislation, any rules, statutes, passed legislations passed by the legislature, ordinances by the presidency. When the legislature passes some acts, and ordinances are given by presidents and governors, so they are also part of administrative law. And some reports and commissions they set up for certain specific purposes. So those reports are also part of administrative law. These are the sources. See, administrative law evolved and administered based on these sources. So there are two types of laws. Okay, private law and public law. Administrative law is a public law. What is public law? That is very important to understand. Okay, public law is between public, that is state, and it can be between some other state or a private individual. But state is involved in public law. In private law, both are private parties. Okay, it is related to private rights. It is nothing to do with administrative. So administrative law, basically, let us say it is between government and maybe private person who is an employee of the government department. Okay. So even criminal law, because state is the party there. So criminal law is also part of public law. CPCs is private law, where Contract Act, private law, transfer of property is private law. So anywhere torts, private law. So anywhere where private, it is between two private individuals or private issues, it is called private law. When it is nothing to do with private, when state is involved, we call it public law. So administrative law is purely a public law. Just remember that one. They may ask you a question. Administrative law is a private law or a public law. Okay. So something like that they may ask. Okay. So the main, as I told, it is evolved from the French administration. It is French administrative law. Earlier there were constitutional laws were there, but this basic administrative law is separated from French. So it is called droit administrative. So administrative law in France is called administrative law. Okay. I'll write here. It is just administrative law in France is called as droit administrative. So Napoleon time it started evolving. So it is purely for they have separated separate law they have created for administrative of government departments. So it is called droit administrative. So from there they have made two separate codes
Excuse me,
independent
sir.
to each
Sorry
other.
for disturbing you.
Yeah.
Who is the father of administrative law? May I know?
See, we call droit is the father normally. Okay. Droit only. That is the name. From his name only it is developed, right? Okay. So there are two independent codes under this droit. Even now we have two separate, but there will be multiple codes. But this is administrative codes, that is public law related codes, and private codes, that is for civil related cases. Okay. There were no criminal cases, those things, everything was, part of administrative codes only, because administrative codes are public codes where state is a party. Where the state is party, private courts are purely for civil related cases, money related cases, contract related cases, property related cases, torts related cases, where there is a dispute between individuals. They have made two independent organs of judiciary, let us say. So one is dealing with administrative, other is dealing with private. So this started in France. Okay. Anything, the disputes between authorities also will be dealt in administrative courts only. So this is the only basic concept, but we'll not, there is a lot of other things, but they are not useful for our AIBE. If you are purely want to go for administrative law related practice, jurisprudence of administrative law, it will be useful. Or else this up to till administrative law in France is called right administrative. So it is evolved from there only worldwide. There of course there will be something taken from US, something taken from England, all those places. But the main revolution about administrative law started in France. Okay, and again same time there will be two different types of court, administrative courts and private courts under droit system. And another important thing under administrative law, the basic principles. Okay, that is doctrine of separation of powers, doctrine of rule of law. These are two principles where administrative law, for evolution of administrative law, these are the other principles also, because they want to separate powers. They don't want to, earlier all powers were concentrated on the executive only. King was the thing, everything used to done, it was the king who was doing everything, right? So there was no legislature in a lot of countries earlier. So over the period, legislature evolved and judiciary was there for independent review, all those things. But the main administrative law evolution started because they want to have a separation of power so that each one will have their own independent role. There won't be any interference from one division to other division of the government organization, one organization of the government with the other organization. So what is the role of legislature? The role of legislature is to pass on the legislations, acts, statutes. Okay, parliament and assembly, they pass the acts and rules and order. All those things are done by legislature. So executive is the one who implement those things. Whatever is the things resolved in the legislature, parliament, assemblies, executive will be implementing that. Okay. Then it is the judiciary who will review those things. If there is any conflict, if there is any, not doing in proper way, then judiciary intervention will be there. So judiciary is independent role where it is given. What we call is judicial review is part of administrative. That's what I told. It is related to constitution also. You have to read constitution along administrative law along with the constitution because it is very closely related. So judicial review is part of doctrine of separation of powers, because anything passed by the legislature or misuse of that acts by executive, there will be a judicial review. Okay. Then other thing is rule of law. Okay. What is rule of law? Rule of law is above all. Simple. So give importance to the law. So if there is anything law, it is created, it is supreme. So you have to follow the law. Any violation, if any act, let it be executive or legislature, anything passed against the law or the constitution, let us say, they become void or ultra virus, whatever because depending on the act or the order or the legislation, whatever it is. So rule of law is very important. So case one Bharti or some other thing, the basic principles of the constitution, the foundation of the constitution, all those things they have to keep in mind when they are preparing any legislation. So if legislature goes beyond those rules, they can challenge it in judiciary. Okay, judiciary, it will review those things. So that is doctrine of the rule of law. That is, law is supreme above all. So everyone has to follow the law. So even a lot of cases, I'll give the list. I shared, I think, in the morning. Like Keshwan Bharti is the best example. So where basic structure of the constitution is discussed in that one. So any legislation or anything passed, it should not be violating the basic structure of the constitution. And same thing in Menaka Gandhi versus Union of India, where her passport was impounded for some other reason. So it is violation of fundamental rights. So that is also against rule of law. Rule of law, fundamental rights are part of basic structure of the constitution. Okay, that is basic structure of the constitution, and more important is the fundamental rights. So fundamental rights should be protected. So it was for that reason, rule of law, Menaka Gandhi and Union of India, they strike against that arbitrariness of the government. They told it is arbitrary, impounding individuals' passport. It is against her freedom, right of freedom. Okay, right to freedom. So they gave orders in favor of Menaka Gandhi in that case. Okay. So this is another important doctrine of rule of law, doctrine of separation of powers. So keep in mind, they may ask you separation of powers because it is for independent judiciary. That is more important. There should not be any conflict between each organ of the government. So, but same time, let me tell you one thing. In India, there is no strict separation of powers. In India, especially, we are talking about universal, but in India, there is no strict separation of powers because president is executive. Okay. But earlier we saw that sources of administrative law is ordinances. Ordinances are passed by the president. Ordinances are passed by the governor. So sometimes they play the role of legislature also. Okay. So, and president is having pardoning power. So judiciary, let us say judiciary gives death penalty to some convict. President can pardon. President can reduce the term of the convict. So president is here interfering in the judiciary also. But so that is the reason. But so it is academic purpose. I am telling you, in India there is no strict separation of powers. But under administrative law, we have to learn legislature, executive, judiciary. There are separate division. Each are having separate. There is clear division of powers between all those people. Okay. So, but except in India, there are some exceptions are there. Okay. So this is another important concept of administrative law. You will get questions, delegated legislation. Okay. So this is very important because under this delegated legislation, the power of making law is given to the executive. Okay. This is power of making law is given to the executive. Let us say government passed some municipal act. Under municipal act, they can say the commissioner can fix the penalty or collector can fix the penalty in some cases. Collector can distribute some lands, whatever it may be. So he can make some revenue related laws. Or let us say police can fix some type of penalties on certain these things. They can make a rule that this road is one-way traffic. That is rule, right? That is an order. But police are, because that is delegated to them, that power of imposing one-way traffic in the specific road is a law. Police cannot make laws. But because that power is given through some legislation, legislature has transferred that power, that police, especially some superintendent of police or commissioner, whatever it is, some certain level person, they pass on that authority to pass on certain orders so that it is not, legislature is not burdened. Basically, the legislature is having a lot of important tasks, putting one-way traffic, everything coming to legislature to pass on simple acts. It will be difficult for legislature to function. So some not so important functions, which is of daily administrative related functions, they delegate such powers to local administration, that is local executive. So that is delegated legislation. So delegated legislation, they have to follow as per the rules. What is delegated to them, they have to follow in law. That is, law is supreme. So whatever is delegated, they have to follow in the principles, guidelines, whatever is given to them. If they go beyond those powers, it is then void. That whatever the imposition, fine, act, rules, whatever they pass, based on the delegated legislation power, they will become void. So a lot of administrative cases come on basis of delegative legislation, because suspending some person, okay, that suspension, see, who will give power to give punishments? It is the courts, right? Punishments are given by the court. But superiors, collectors or chief secretary, they issue suspension orders to some executive. Let us say some clerk, officer, whoever may be in the government department, just may suspend. So, SP may suspend a police inspector or a constable. So it is a punishment. Police executive doesn't have punishment powers, but because of delegated legislation, they are getting those powers. I think I'm clear here. So if the person who is suffering that because of that act, if he feels that it is beyond that jurisdiction, he will go to administrative tribunals or administrative courts to challenge those decisions. These normal decisions of executive administrative decisions, they have to be challenged in administrative tribunals only. There will be a separate tribunal, is like some court, as we discussed earlier. You think it as a court, so they will go and file in the administrative tribunals. So then there will be administrative appellate tribunals also. Then they will go to high courts. So first tribunals, then appellates, then they come to high court if they are not satisfied with those orders passed by them. Then they can go up to Supreme Court also. So even public can file against writs against the executive also, if they are not performing, like there are different types of writs, right? So they can file writs, that is part of judicial review. So that executive is not performing their duties, so they can file those things. Okay. Then there are certain concepts. 1 minute, I'll just try to look into that. So there is another thing called sub-delegation. Sub-delegation is not allowed. If you are delegated to something, you have to do your own duties. You cannot sub-delegate these things. So only certain small maybe support systems they may take, but technically sub-delegation is not allowed. So anything beyond their powers, what are delegated, if they go beyond that, it is ultra virus of the act. So parent act. So you can challenge in the court. So the administrative law is based on two things. That is based on main one thing only, natural justice. Natural justice, there are two things, important things. That is, one is rule against bias, and other is AIBE altrum partem. So this is very important. You get a lot of times this specific AIBE altrum partem. That is, we will know that what is basically rule against bias. Okay, so there are see, rules of bias. There are three bias actually: pecuniary bias, personal bias, subject matter bias. Okay, so if it is self-interest is there, pecuniary or personal bias, if there is a bias, then you cannot, you will be not in a position to take action against those people. So let us say, I am the boss. Okay, I am the person to decide on my suspension. Okay, so it is personal bias. Okay, I cannot decide on my own. I am the convict, so I cannot decide whether I did right or wrong. Okay. See, please don't write on this thing. Okay, so I invested some money in specific factory, and I had to give permission to that factory. Then I cannot decide on that matter. Okay, so these are the bias against rules against bias. So you will be biased in taking certain decisions. So that you have invested money, or you are involved in that crime, or you are involved in any other thing related to that. So you, as an official, you are it is against natural justice, because always, since you are involved personally, there may be a possibility of bias. Okay, so let us say, not you, personal bias is your friend, your wife, somebody is investing in some company, and you are supposed to give some permission. You are about to check whether the company is doing proper or not, whether they have violated any law. So it is against natural justice, principles of natural justice, because you may be biased. So you will not be allowed if there is any pecuniary bias, that is, your money is involved, personal bias, where your family or friends or you are involved. Okay, and subject matter, where you are also interested in that particular subject matter, you will not be allowed. Then AIBE alterum partem is basically here the other side. AIBE alterum partem is the, here you get this meaning. I'll write here. See, this is very important part of natural justice. Okay, hearing the other side, you have to give opportunity to other side. If you are taking some action on somebody, you will get a case law certainly on this one. There may be lot of times you get this one. So opportunity should be given to the opposite party to explain his issue. So if you are going to take some action, first you have to issue a notice. Okay, so issue a notice that we are going to take action against you in this so and so. You have to give explanation. So within so and so 15 days, you have to come and give your explanation, defense from your side. So if defense is not allowed, it is against principles of natural justice. Okay, so here notice is given. There is only one particular thing we discussed in CPC, where defense is not allowed automatically. What is that? Under which place defense is not allowed automatically? We discussed in when we are doing CPC. Order 37 summary suit. Okay, that is the only place where defense is not allowed automatically. We have somebody told how is it possible. Also, we discussed on that one or 2 minutes also on that particular thing. Okay, defense is not allowed automatically. There is a procedure to avail that defense. So, but other times, apart from that, especially Order 37 of CPC, all other places, you have to give opportunity to the other side to defend himself. So he can do only when you allow him to give a notice. You give a notice, then you give a fair hearing to his answer. Without fair hearing, you cannot decide. If you feel if the person feel that you are not giving any opportunity of fair hearing, he can go to the tribunal against this action. Okay, so if any action is taken, see, we are talking about administrative law. Is administrative law, something happens, it will be challenged, or some action is taken against some junior by the superior, it will be challenged. That is more of the administrative law. So when somebody is giving someone or some notice, show cause notice, or whatever it is, that is part of natural justice only. Notice is given, then that person will be explaining why he has done. There will be a committee, commission, they will go, they will present their case, they will give the details, information. Then the committee will decide based on the notice, based on the allegations, based on the excuses and evidences the person brings in. The actual person against whom the allegations are made, whatever he is bringing, based on that, action will be taken. So if that person is not happy with the action, he can go to the next level, High Court, Supreme Court, all those things he can go. So this is basic concepts what we are doing. So rule of law is very important. Supremacy of law, equality before the law, everyone are equal. Predominance of legal spirit, we have to give importance to the legal spirit. Why? See, there are two things. Legal spirit means whatever is written in the book law, so that is in letters. So there is something beyond that. So why they have written like that? Administrative law, they will write some rule. So the spirit behind that, what is the reason they have written, made that legislation? What is the reason they have made that rule? The main purpose. So some good reason they have made it. But if they are misusing that, it may be in writing, it may be different. But actual the purpose of doing such, passing that legislation, the spirit, what we call it, that is the spirit. What is behind that, making that law is called spirit. Spirit ante, don't think like whiskey or rum. Okay, the spirit is legal spirit. It is the purpose, the objective of making that law. So the rule of law, we have to go beyond that law. What is the purpose of making that law? That is jurisprudence. Basically, what we call is jurisprudence. And previous legislations, previous judicial, orders, whatever it is, decisions, based on that one, that is rule of law. That is AIBE Dicey. That is the important person when rule of law is called. Who is the person who was talking about rule of law? It is AIBE Dicey. Remember this. Okay. So this is the administrative law, governs the powers, procedure, remedies related to the government administrative agencies. It ensures government actions are not arbitrary, abused, or uncontrolled. So government is going as per the rule of law. Administrative law purpose is see to that government functions as per the law, because law is supreme. So delegated legislation, already we spoke. This is the explanation. 1 minute. So why delegated legislation? Lack of parliamentary time, technicality of the subject matter. This is another important thing. Why delegated legislation? Because parliament may not have technical expertise. So they delegate certain tasks, like they form a committee. Initially we thought sources, right? Administrative law. So the committee will decide what the framework should be there, what should be the guidelines. Let us talk about, say, pharma related act, patent related act. So scientific inventions, innovations, parliament legislators may not have that technical subject matter. So for that reason, they give that power to executive specialist. They appoint a committee, whatever it is. So they make those specific related laws in that subject matter. So parliamentary control, judicial control. Okay. ultra virus we spoke. Anything beyond that for delegated legislation, it is ultra virus. So, okay, this I didn't speak. The rule against bias, it is called nemo judex in causa sua. Okay, so this whatever terms you tried, you have to by heart these things or remember some clues. Nemo judex in causa sua. That is rule against bias. No person shall be judged in their own cause. This ensures impartiality. Rule against bias means bias, pecuniary bias, personal bias, or some other bias. You cannot judge for yourself or your friends or when your interest is involved, subject matter, your interest is involved. So you cannot judge again in your own cause. That is nemo judex in causa sua. So maybe I can try to understand my own case. You cannot judge where your interest is involved. Okay. AIBE alteram partem, we discussed about this one. Here, the other side, no person shall be condemned unheard. So you have to hear him, then only you can take the decision. So fair hearing should be given. Okay, pecuniary bias, personal bias, subject matter bias. Okay, this is the case law. This is important. Okay, Cry Park versus Union of India. They have asked this question. Okay, landmark case in this rule against bias. Okay, so you can remember Cry Park versus Union of India. Rule against bias. So right to notice, this is AIBE alteram partem. What is the thing? Right to present case, right to rebuttal, reason decision. Okay. Review illegality when you can go to tribunals, malafides, bad faith, impropriety procedures they haven't followed. You can all do those things. Okay. What is the tools available is mandamus. Okay. Certiorari, prohibition, quo warranto. We have studied about these writs in Constitution. So you can use these writs to challenge any legislation. You can use go through pill also certain things. Okay, certain things the suffered party will take care of those things. Okay. Legitimate expectation. This is another doctrines. A person may expect to be treated in a certain way based on the administrative author past practice or clear promise. Breach of this expectation can be ground for judicial review. Doctrine of proportionality. This is important. Doctrine of proportionality. The legitimate expectation. Okay, I didn't see this one a lot, but doctrine of proportionality, you get this thing. So the administrative action must not be disproportionate to the wrong committed. So somebody made a small mistake. So you cannot give a big punishment. So last 10 days back, there was a small video on YouTube by Secretary, I don't know the designation, Praveen Prakash. He is an IAS officer in Andhra Pradesh government. So he was explaining, he took some decisions because the mistake was small because they have used official car for personal purpose. So they are available 24 hours. So that is, just giving an example, they have used that car to go to his movie, let us say. So for that reason, they were suspended for 2 years almost. So that proportionality, doctrine of proportionality, a lot of people do such minor things, especially when their administrative punishments are given. So there should be proportional punishment, which is equal, I mean, related to the, please don't mess on the, Shailaja, please don't play on the screen. Okay. So it ensures the balance between used and unsought. Okay. So doctrine of proportionality is that main thing. Okay. So this is all about administrative law.